Good afternoon and welcome to the Environmental Law Institute. You've joined us for NEPA, ESA, and the Fundamentals of Environmental Law. My name is Hannah Keating and I'm the Manager of Education Programs here at ELI. We are delighted to welcome everyone to the second seminar of ELI's annual Summer School series, and I encourage you to join us here at ELI every Tuesday for Summer School. For more information on Summer School and as well as programming, please see the events page on our website, eli.org. Thank you all for joining us. At the end of today's panel, we will have time for questions and answers, or question and answer session, and we encourage you to ask your questions at that time. If you're joining us in the room, we have a microphone to bring around at that time. If you're joining us through GoToWebinar, please submit your questions through GoTo's question box, and please do not wait until the end. Send them as soon as you think of them. I would like to extend a huge thank you to our outstanding panelists for joining us today to lend their leadership and expertise to the summer school session. While I introduce them briefly in a moment now, their full speaker bios are posted on our website, eli.org, and I encourage you to check out their expertise and experience in more detail there. As we begin, I would like to briefly introduce our panelists now. Jake Lee. Jake is the Director of Biodiversity at the Environmental Policy Research Center, which focuses on developing innovative strategies to conserve imperiled species. Jake specializes in the endangered species law, policy, and science, and his work includes nearly every aspect of the Endangered Species Act, especially consultation, recovery planning, and funding. Jake's approach emphasizes the use of data science to yield evidence-based approaches to understanding the strengths and weaknesses of the Act and other wildlife conservation programs. Prior to his work at the Environmental Policy Research Center, Jake held various positions at the Defenders of Wildlife, including Vice President of Endangered Species Conservation and the Director of the Center for Conservation Initiative, as well as Jake practiced environmental law at Latham & Watkins LLP. I'd like to now briefly introduce Anne Navarro. Anne is a partner at Bracewell, where she advises on litigation under the federal laws and policies governing natural resources and the environment. She has advised on some of the most challenging and high-profile policy issues in natural resources and environmental law, including NEPA reform, federal permit streamlining, wetlands protection, and protected species policy. Anne has held senior legal and policy positions at the U.S. Army Corps of Engineers and the U.S. Department of Interior, including most recently as counselor to the solicitor at the Department of Interior, and has spent more than 10 years as a trial lawyer in the Environment and Natural Resource Division at the U.S. Department of Justice, as well as 10 years litigating and managing civil works litigation for the Army Corps. As you can see, we have a really fantastic panelist lineup with a wonderful variety of expertise and experience. Thank you both so much for contributing to the 2019 Summer School Series. And with that, I'll warmly turn things over to Anne to get us started.
All right, thank you very much, Hannah. That was a lovely introduction. Let's see, I'm just flipping through the first few slides. All right, so I'm here today to talk about called NEPA 101, the fundamentals of the National Environmental Policy Act. And I just want to put it in a little bit of context in terms of my experience with NEPA. I love NEPA. I think it's a fabulous statute. It's a very interesting area of the law to practice in. I started handling NEPA issues when I was a litigator at the Department of Justice. And when I was a young lawyer at DOJ, and I was told that I was going to start handling cases under the National Environmental Policy Act, and that it was a process statute, I was kind of disappointed, right? Because you go to be an environmental lawyer, and do you really want to handle process issues, or do you want to handle, interesting Endangered Species Act issues where you really get to protect living creatures? Well, I didn't fully understand what NEPA was, fair to say, in my career at DOJ, because in fact, NEPA is an incredibly powerful tool for the government, for the public, for stakeholders, for the private sector, for NGOs, for everyone, because by way of NEPA, the government has to take into account environmental considerations in its decision making. In the environmental area, and applies to, but it is absolutely critical to the private sector for a variety of reasons. Every federal action is subject to the requirements of the National Environmental Policy Act, or almost every action you can think of. And so if you apply for a permit, a grant, a license, anything like that, propose a project, seek funding, anything that you do that requires an approval from the federal government, many of those things require the government to review your proposal under the National Environmental Policy Act. So from an applicant's perspective, interacting with the federal government, it's a crucial statute. And of course, it's a very important tool for environmental groups, other stakeholders who have concerns about the sufficiency of the government's review of environmental issues. It's a very important tool for those actors to bring those concerns to the attention of the federal government and challenge the government's analysis. So the first slide is just a basic on what NEPA is, the citation. The second bullet is the regulations that implement the National Environmental Policy Act, which were promulgated by the White House Council on Environmental Quality many decades ago. And NEPA is a really influential statute in terms of its influence on states in this country as well as by foreign countries. Many states have subsequently adopted NEPA-like statutes, and the basic principles of the statute have been exported to many different countries. In that little box at the bottom of the slide, you will see a link to the website that has the repository of pretty much everything NEPA related, the regulations, policy guidance, handbooks, interpretations by CEQ, all the good things that you need to be a NEPA practitioner that are not specific agency specific are at that link. And it's good to know the link because it's a little bit weird in that it lives on a Department of Energy webpage. So sometimes folks have trouble tracking it down. Since this is NEPA 101, I just want to what the context was in the country when NEPA was enacted, signed into law on January 1st, 1970, because it was really one of the first all-encompassing major environmental laws. And some people I've worked with in the past have expressed some frustration about some of NEPA's requirements. And they say, well, but why do we have to do these things? You know, the government's good about taking environmental issues into account. The environment's pretty good. You know, where does all of these requirements come from? Well, in terms of what was going on in this country in the 1960s, leading up to passage of the National Environmental Policy Act, things weren't so great. There was already a lot of both international and domestic conversation around various specific environmental issues. Clean air had certainly been an issue already for a long time, but there was starting to be more consensus in this country and abroad about the need for more assertive regulation of air. The White House held one of its first kind of environmental focused meetings in 1962. Rachel Carson came out with her famous book about pesticides in 1962. You had an early version of the Clean Air Act, an early version of the Wilderness Act. There was a decision by an appellate court in 1965 that kind of put a lot of these issues on the front burner. There had been a plan to build the largest pumped storage facility in the world in a mountain near Cornwall, New York on the Hudson River. And the Federal Power Commission at the time had just approved that without taking into account all the concerns about adverse environmental impacts to the river, aesthetics, et cetera, et cetera. In 1965, the Second Circuit Court of Appeals set aside that approval on environmental grounds and said, you know, no, you have to think about all these different impacts before you issue that decision under statutes that were specific to the Federal Power Commission. That was a real watershed moment. because it was the first time in a major environmental case litigants had really established standing and that these issues were meaningful in terms of judicial review. Following that, there were government plans to dam the Grand Canyon to produce more hydropower. Those were also stopped. One of my favorites is the Cuyahoga River outside of Cleveland, famously catching fire in 1969. So there were all these things going on that were driving the national and international conversation about environmental protection. And all of that is what contributed to the environment that led to the passage of NEPA, and then the establishment of EPA, the passage of the Clean Water Act, and the ESA. So the senator who introduced NEPA was named Henry M. Jackson. He was a Democrat from Washington, and he was the chair of the Energy and Natural Resources Committee in the Senate. And he kind of put a fine point on the purpose. He basically summed up what had been going on, explaining that we're just not dealing with these issues adequately, these environmental problems and crises. We need to have a system that will allow us to identify and evaluate these challenges, before we undertake action. So NEPA is a pretty inspiring statute, I think, when you read the purpose and the policy of it, which probably most practitioners, including me, except I had to prepare for this, haven't read in a long time because they don't necessarily inform the day-to-day application of NEPA. But it's pretty inspiring when you read it. Congress wanted to declare a national policy which will encourage productive and enjoyable harmony between man and his environment. So it was a pretty all-encompassing purpose. Going on with the policy, Congress wanted to create and maintain conditions under which man and nature can exist in productive harmony and fulfill the social, economic, and other requirements of present and future generations of Americans. So pretty inspirational stuff, really. So what exactly is NEPA intended to do? And this kind of goes back to my initial misunderstanding about what NEPA was intended to do when I started handling NEPA cases at the Department of Justice. NEPA is intended to have an action-forcing influence on agency decision-making. So NEPA makes an agency think about the potential environmental impacts of its action in the hopes that once the agency identifies and thinks about those impacts, that it will then choose an action that mitigates or lessens or avoids those impacts. So while NEPA itself is not intended to compel any specific decision, it is hoped that by way of this analysis, review, and public disclosure, that agencies will make better environmental decisions. So at bottom, NEPA does not require government agencies to make good environmental decisions. Agencies are free to make the most damaging and worst possible environmental decision under NEPA, as long as they've gone through the process to analyze the impacts and alternatives and appropriately involve the public in their review. So it's intended to improve agency decision-making. And very importantly, NEPA is intended to require that the government inform and involve the public in agency decisions. So no more kind of closed-door decision-making when it comes to environmental review and impacts. The drafters of NEPA very much wanted the public to understand the implications of government decision-making. Not only is NEPA not, though, intended to compel any particular decision, it also doesn't change the obligations and responsibilities of agencies under other substantive statutes. So, for example, if you need to apply to the Fish and Wildlife Service for a permit under Section 10 of the Endangered Species Act, in order to process that permit, the Fish and Wildlife Service will have to undertake a review consistent with NEPA's requirements, but there's nothing about NEPA that changes the obligations and responsibilities of the Fish and Wildlife Service under the Endangered Species Act. So it's kind of a layering effect with other statutes that may be applicable. I want to talk a little bit about, just in terms of the logistics, kind of about how NEPA is implemented. So the Council on Environmental Quality, which is part of the White House, it sits in the Executive Office of the President, is responsible under the statute for certain aspects of NEPA implementation. They are responsible for promulgating and interpreting NEPA regulations, which, as I said, have not changed in decades, but stay tuned, they may be changing. CEQ is responsible for reviewing the NEPA procedures of other agencies. And then they can do various things under the NEPA regulations that are mostly aimed at coordinating the federal agencies. Like if more than one federal agency is involved in a project, if necessary, CEQ can help designate who might be the lead for that project. They can also make alternative arrangements if there are emergencies where a federal agency has to take immediate action without time to go through the NEPA process. And that is pretty common. And actually most agencies have their own emergency procedures, but in certain instances, the agency needs to go to CEQ to coordinate what usually turns out to be kind of a post-action review in order to comply with NEPA. So that's generally what CEQ does. EPA has a very narrow role in NEPA implementation that has been somewhat controversial over the years, in that EPA reviews and rates environmental impact statements, which, as we will discuss, is one type of analyses that NEPA requires. So they're responsible for giving your environmental impact statement a grade, which, as I'm sure you can imagine, irritates other federal agencies to no end. They also kind of are responsible for the public docket on environmental impact statements. So they publish notices of availability in the Federal Register of EISs. And then, of course, every other federal agency has to comply with NEPA to the extent it applies to their actions. And most have their own NEPA regulations and procedures. So as you can imagine, with such a significant federal statute, there's a nice set of Supreme Court case law on various aspects of NEPA implementation. You see these two cases cited quite a bit for some of the basic kind of foundational concepts of NEPA, Vermont Yankee Nuclear Power Corp. And Robertson v. Metho Valley Citizen Council. Both articulate what everyone now agrees to be kind of the mandate of NEPA, which is generally to ensure that the agencies issue a fully informed and well-considered decision that carefully considers significant environmental impacts. So we've talked a lot about the history and the overall purpose of NEPA, but what exactly does NEPA require? So as I said, NEPA does require process. It requires analysis. The statute itself is pretty simple and straightforward. It says an environmental impact statement is required for every recommendation or report on proposals for legislation and other major federal actions significantly affecting the quality of the human environment. So all the statute speaks to is major federal actions that may have significant environmental impacts, and those require an EIS. And typically an EIS is a fairly substantial, often multi-volume analysis. It can take anywhere from a year to 15 years to complete, depending on the nature of the action and the motivation of the particular federal agency. So that's really it. in the statute in terms of the process that's required, but CEQ elaborated on that in the regulations that it promulgated. Actions that may not amount to a major federal action significantly affecting the quality of the human environment may also require a NEPA review. And there are two other types of NEPA review that I'm going to talk about in some detail. So in addition to the EIS, there are two other types of NEPA review, two that are established by the CEQ regulations. First, there's something called a categorical exclusion, which many people shorten to call a CADEX. And the CADEX is not really it's not a long analytical document. Rather, it's a category of actions which do not individually or cumulatively have a significant effect on the human environment, and for which, therefore, neither an EA nor an EIS is required. So most agencies in their NEPA implementing regulations or procedures have identified categories of actions that they don't have a significant effect and don't require any separate or individual analysis for those actions. Examples of those types of categories might be things like buying office supplies or promulgating regulations related to the agency's administration of its financial system, or things, and they can also be more substantive. I believe the Department of the Interior had a CADEX for certain types of fire prevention activities. So it can be a range of types of actions, but it has to have been developed by the agency based on a record where they've looked at the issues and come to a conclusion that that whole category will not have a significant effect on the environment. And CEQ gets involved in reviewing that too. So they can't just like sit in a closed room and decide, oh, building 100 new battleships won't have a significant effect on the environment. They have to go through a process and establish a category. And it's not a NEPA exemption, that NEPA process. Thing to note that sometimes trips agencies up is that an action that is normally subject to a categorical exclusion could require an EA or an EIS in the event there are unusual or extraordinary circumstances. So I remember I once worked on a case with the National Marine Fisheries Service. They had a categorical exclusion for certain types of permits relating to research relating to marine mammals. But they issued a permit under the CADEX. It was challenged and we lost because the judge decided that the type of research that this particular researcher was going to do was extraordinary and unusual in that he was deploying sonar arrays in migrating pods of whales. And so the judge thought that fell under the extraordinary or unusual circumstance. So just because you have a CADEX doesn't mean you can always use it. And also one more thing to note about CADEXs is most agencies wisely have some sort of paperwork requirement. So there's some minimal explanation as to why the CADEX applies, how the action fits, and that there are no extraordinary circumstances. Because most courts will, if challenged, will want to see that the agency thought about whether it applied. Type 2 of review under the National Environmental Policy Act is the environmental assessment. This is probably the most common thing that agencies do, and certainly one of the most common types of review you see in litigation. So an environmental assessment is kind of a mini EIS because you're going to look at all the same kinds of issues but not in the same level of detail. It's supposed to be a concise public document that explains the action at issue and does the required environmental review, and aids the agency in complying with NEPA when no EIS is necessary. The regulations require some sort of public disclosure in the environmental assessment process. They don't have a specific requirement. So a lot of agencies, they do that very differently. There are some agencies that actually have their own procedures or regulations that require that they put their draft environmental assessments out for 30 days of public review. That's not required by the statute or the regulations. Some agencies will simply issue a public notice that they are embarking on a particular review process. So there is some public participation aspect in the EA process, but it's not kind of nailed down, and it varies by agency. So at the end of the environmental assessment, there might be two different results. One, if the review confirms that no EIS was necessary because it wasn't a major federal action significantly affecting the quality of the human environment, the agency signs a finding of no significant impact, or FONSI, and explains the reasons for its conclusion. Or it might go the other way. They might have uncovered information in the EA process that leads them to conclude that in fact an EIS is necessary and appropriate. So then the agency would go into the EIS process. Note that you don't have to do an EA before an EIS. So in most circumstances, I would say agencies kind of know up front that a project needs an EIS and just starts into that process. So I've already talked a little bit about environmental impact statements. The conclusion of the environmental impact statement process is a record of decision. And that is also defined in the regulations, or a ROD. And you see RODs, you know, again, the nature and length of them kind of covers the waterfront. But the ROD is supposed to identify what the decision is, what alternatives the agency considered, discuss kind of factors that were balanced by the agency, and talk about what methods were taken to avoid or minimize harm, and whether any mitigation is being adopted. Note that even though NEPA doesn't require mitigation or dictate any substantive outcome, once you sign a ROD and it incorporates mitigation, then you're committed to that, because you've based your decision on those actions that you describe in the ROD. So one of the big questions that you see a lot in litigation, and frankly that a lot of federal agencies and consultants and outside permittees struggle with, is how do you evaluate the potential significance of impacts to determine if an EIS is required? I mean, there's no measuring stick, there's no kind of go by. So it can be pretty subjective. But luckily, CEQ in its NEPA regulations gave us a list of factors. I meant to pull those out. A list of factors to consider when evaluating whether an action might trigger an EIS. And those factors are such things as the degree to which the proposed action affects public health and safety, unique characteristics of the geographic area, effects on protected species, effects on cultural resources. So they gave us a list of factors to think about when evaluating significance. But maybe most importantly, the regulations tell us to consider those factors in the context of both the context of the action and the intensity of the action. So these pictures on the slide are just kind of meant to depict what that concept is. You know, if a federal agency has been asked to issue a permit to cross a stream in an active mining area, the context of that action for that new road, you know, it's a pretty degraded environment already in a mine. So you would take that into consideration. Whereas if the agency, the Corps of Engineers, say, is asked to permit a road through a pristine marsh on the other hand, well, that context is very different. And so even though the road may not be a very intensive use, because of the pristine context, that will change the nature of the analysis. So it's a little bit of a subjective analysis, and it requires agencies to really think and really document what they do. So in terms of the essential elements of the NEPA analysis, there's kind of two buckets of what the central elements are. There's alternatives and consequences or impacts. So under NEPA, in EISs and EAs, federal agencies are required to consider alternatives to the proposed action. So you have a proposed action that's a simple dock, and then maybe you look at different ways to construct the dock, different sizes, different ways to accommodate boat traffic in the area, whatever the reasonable range of alternatives might be. An agency has to come up with a reasonable range and then evaluate the environmental impacts of each of those alternatives so that the decision maker can make a choice of alternatives, or maybe the decision maker chooses hybrid, a hybrid alternative. So that's the alternative kind of approach. And then the other those actions, or as they're defined in the CEQ regulations, the impacts. And there are three types of impacts that agencies have to consider. Direct impacts, which are caused by the action, and installation of the dock. Then indirect impacts, which are still caused by the action, but maybe occur separate in time or distance. So I would view an indirect impact as a dock as bringing boats to the area. So that's an indirect impact. And then let's look at cumulative impacts. And in my little picture, that's lots of boats, you know, because maybe this is the 10th dock in an already busy area. So the agency would have to consider the cumulative impact, not only physically of locating the dock there, but what it might mean for the environment in the relevant area. And as you can imagine, direct impacts tend to be pretty straightforward and not too hard to identify. Indirect and cumulative impacts get a lot harder, and there is a lot more litigation over the sufficiency of an agency's consideration of indirect or cumulative impacts. And the Supreme Court has weighed in on this as well in a case called Public Citizen. And I expect that this will be addressed in potentially upcoming reform of the NEPA regulations. So I've mentioned litigation a lot, which makes sense because I used to be a litigator and that's where I first learned about NEPA. But litigation is really important to the development of NEPA law, to the agency's ability to make decisions, to private sector's ability to get projects underway, and to the ability of stakeholders and others to influence agency action. So there is a fair amount of NEPA litigation. I mean, pretty much every federal agency has their fair share. I just wanted to note that there is a great deal of NEPA law that is almost like common law because the statute is so simple and not very precise that cases tend to fill in a lot of the concepts that NEPA practitioners need to be familiar with. And courts are very experienced in NEPA cases. What they expect the agency to do is to have taken a hard look at the issues in front of it and to really show, the agency needs to show its work. It needs to show that it's considered the relevant factors and articulated a rational connection between the facts found and the choice made. And it's remarkable how hard that sometimes is, because agencies certainly win a lot of NEPA cases, but they also lose their fair share, because it can be difficult to sufficiently explain the agency's analysis. So there's a lot of NEPA topics that we don't have time to talk about today. And so I've tried to provide you a probably partial but pretty comprehensive list of kind of key NEPA topics that come up for practitioners that are relevant to the private sector, and that also come up a lot in litigation. And I'm just going to flag a couple of these before handing it over to Jake. Oh, and I think I have one more slide after this. Couple of particular interesting things, supplemental analyses. Sometimes NEPA gets old, or there's something incorrect about it, or the agency action changes. If those things happen, in certain circumstances, agencies have to supplement their NEPA work. So that's kind of a key thing. It's also possible for agencies to adopt NEPA work done by others. So, for example, if the Corps of Engineers is considering the issuance of a permit under the Clean Water Act related to a road project, it could adopt the NEPA EIS done by the Department of Transportation, and basically take ownership of that and then make its own decision based on that NEPA work or with some supplemental NEPA work. So just a few to highlight those. NEPA has not changed a lot in a very long time, but in this administration, there have been some changes, and I expect some more. In particular, the Council on Environmental Quality has given notice that it intends to propose revising the very long-standing NEPA regulations. So that's a big deal, because these regulations have not been touched in decades, and when they were touched after promulgation, it was just once in a very minor way. So this is a big deal to a big community, and we expect to see that proposed rule. They keep saying very soon, but I honestly now expect it pretty soon. Probably when I'm on vacation in 2 weeks is when it's going to come out, is my guess. The other thing that's been going on is that both the White House and various agencies have been trying to implement process reforms. So the private sector and the government have, often have concerns about the length of time the NEPA review takes, the length that the documents can grow to. I mean, you've seen the Department of the Interior doing a 10,000-page environmental impact statement. Some of these big projects can take years. So both the White House and agencies have been trying hard to get a handle on that, to implement some common sense reforms that really every administration since I've been in the federal government since 1991, every administration has made some run at trying to get NEPA kind of back to what it was supposed to be, which is an efficient decision-making tool. I mean, a decision maker is not going to read a 10,000-page environmental impact statement. So there needs to be a way to make sure the government is adequately considering information, but in a useful and efficient way. Just a couple of those reforms. The White House has issued an executive order 2 years ago directing that where federal agencies, multiple, are involved in a major infrastructure project, that they have to get together and do one NEPA document, issue one record of decision, and do it on a certain timeline in order to try to improve efficiencies. The Department of the Interior in particular has been pretty assertive about trying to make the process more efficient. They've said no more 10,000-page EISs. We want an EIS for a normal project in 150 pages and an EIS for a complicated project in 350 pages. Obviously that's a lot shorter than people are used to. So kind of, I think, everybody's still figuring out how that's going to work and how to go forward with those types of directives. So it's an exciting time to be working in NEPA. And that's it. Now for endangered species.
Great, thank you. And before I get started, I'm going to see if I can move this laptop over from the rubbernecking to the laptop. Great. Well, thank you all for your interest in this topic. Before we get started, I just want to make one clerical correction, which is the name of my organization. It's actually Environmental Policy Innovation Center, or EPIC, which I think is a far cooler name than EPIRG. So if you want to look for us, look for EPIC. Our website is policyinnovation.org. Great. Well, I work almost exclusively on the Endangered Species Act, and I think it's a really, really fascinating law to work with because it's a lot like NEPA. It's actually one of the simplest and shortest of the federal environmental laws. It's not hundreds of pages like the Clean Air Act, for example. It doesn't have very, very prescriptive standards for many of the key decisions that have to be made. And as a result, there's actually a lot of ambiguity and flexibility and wiggle room in how the ESA is implemented. And it's that wiggle room that I find to be really fascinating because there can be quite a bit of variation in how the ESA is administered for a particular type of decision when you shouldn't think there would be that much variation. The other thing I find really interesting about the ESA is that I actually think Congress has given our federal wildlife agencies an impossible task. And I think that can be said of many federal agencies. I think all federal agencies will say, well, they don't have enough money, right, to do all the things that the law requires. But it's really, really evident and really acute when you look at how the ESA is administered, that the resource shortages are so significant that, one, you get a lot of litigation sometimes over the federal wildlife agency's failure to meet its legal deadlines. And then two, it raises the bigger question of, can the ESA actually ever achieve its two goals that we'll talk about? Is there enough money? Is there enough political support? Is there enough support on the ground in rural areas in America where a lot of endangered species are found to actually support the full conservation of those species? So I just want to put that out there because oftentimes the ESA in practice is a lot more complex than it appears on its surface. And we'll try to walk through some of the basics of that. Great, so what I want to do with this course is I have kind of two broad goals for all of you. First is to give you an overview of how the ESA works, how its regulations and policies are structured. But while I do that, I also want to give you some basic statistics about how the law is implemented so that you have some context to understand where the law is actually working and where it's not working. Because again, we get back to this point of slippage. I think Congress has given our federal wildlife agencies an impossible task. And the way to figure out where the act is not necessarily keeping up with its intent is to actually look at the empirical data, to look at how the law is implemented, and to look at that difference between intentions and actual day-to-day practice. Now, as far as the content of our course, I want to organize it into sort of four main sections. First is I want to quickly touch on the three main goals of the ESA. And then we'll turn to the structure of the ESA, which is where we'll spend most of our time. And some of it may get a little bit into the weeds, but I'm trying to not to get too much into weeds because I think all the topics I'm covering are also oftentimes covered in the media. So some of you might have seen that the Trump administration has proposed very, very extensive revisions to the ESA regulations last summer, much like the NEPA proposed regulations. Those proposed regulations for the ESA are expected to be finalized within the next month or two, is what I hear. So when it's on the front cover of the Washington Post or the New York Times, the concepts I'm talking about in the ESA structure will be really pertinent to allow you to really understand what's being covered in the media. Then I want to touch on a few special topics on ESA. So they're a little bit separate from the main structure of the ESA, but are really relevant to the day-to-day practice. And then I want to leave you with some resources for you to learn more about the ESA if I haven't bored you with this talk. Great. So the main goals of the ESA. The first and most urgent goal is to prevent plants and animals from going extinct. This was actually a major reason that drove Congress to pass the ESA in 1973. So Congress looked at the extinction of the Carolina parakeet in 1918, the near extinction of the American bison, and a handful of other species. And it basically said, we as a country have a moral obligation to stop species from becoming lost forever, right? And so there's a really urgent crisis to stop that extinction trend. But it's not enough just to prevent extinctions, right? Congress also wanted species to be recovered so that they no longer need the ESA's protections and can be returned back to state management where they had belonged before being protected under federal law. So another way to think about it is that Congress doesn't want species to be essentially on life support forever, right? You don't want these species on the ESA forever. And so one of these key questions in the data-paid practice is how many species can actually be recovered versus how many need to be on life support forever. There's a lot of literature on this topic, and some people feel that a majority of species might be listed forever, that it's actually impossible to recover every species. My personal view is that's probably true. There are species whose entire habitats will be gone because of sea level rise in the next 100 years. I don't see how you can ever recover a species like that. So maybe the best goal is to prevent those species from becoming extinct, but you may not ever fully get to the point of recovering them and returning them back to state management. Besides recovering species, the ESA also our country's obligations under international wildlife conservation treaties. So the most important of these is something called CITES, which is the Convention on the International Trade of Endangered Species. And it's basically an international trade agreement that regulates the import and export of endangered plants and animals. So sometimes you'll see in the news about people wanting to import lion parts from Africa as hunting trophies, right? So those parts are regulated under CITES, and ESA allows the federal government to implement those CITES obligations. So again, you can think of these three main goals of the ESA, with recovery and extinction prevention being, in my mind, sort of the main driving goals. So now let's talk about who's responsible for actually implementing these big ambitious goals of the ESA. The statute gives the primary responsibility to two federal agencies. The first one is the U.S. Fish and Wildlife Service, which is located within the Department of Interior. And the Fish and Wildlife Service actually is responsible for 93% of all listed species. So we currently have around 2,350 species listed throughout the world. And Fish and Wildlife Service has primary jurisdiction for about 93% of those species. The other agency is NOAA Fisheries, also known as the National Marine Fisheries Service, and that's within the Department of Commerce. And so NOAA Fisheries has the lead for all marine species and something called anadromous fish, which are basically fish that are born in freshwater but spend a lot of their lives in saltwater. And probably the best example is salmon, right? They're migratory fish. A lot of sturgeon are also anadromous fish. So that's NOAA Fisheries. Fish and Wildlife Service has all the terrestrial and freshwater species. Now, if it were up to just these two agencies to achieve the ESA's recovery goals and extinction goals, that would basically never happen. The services don't have enough control over land and water to achieve that goal, nor will they ever have enough money, right, to fully recover all species. That's why the ESA also, in Section 7, puts it upon all other federal agencies to help recover species using whatever authorities those agencies have. So EPA, the Department of Defense, FAA, for example, they're all supposed to help conserve endangered species. Whether they actually do so in practice is maybe the subject of a ESA 102 or 103 talk, but at least on paper, this is what the ESA says. All right, so ESA's goals, how well are we meeting those goals? All right, well, let's look at some of the numbers here. So far, there have been only 11 confirmed extinctions. So these are species that have been confirmed extinct and officially delisted under the ESA due to extinction. But I need to add a footnote here, and this is an important footnote. There are dozens of additional species that are presumed extinct or very likely extinct, but the Fish and Wildlife Service simply hasn't had the time to actually issue a rule to say these are officially extinct. So the 11 confirmed extinctions actually downplays the true nature of how many species have actually very likely gone extinct under the ESA. Now let's look at the other goal, recovery. So only 55 species have been recovered to date. That's less than 3%. And some folks who want to amend the ESA say, look at this. This is a sign of failure of the ESA, right? I think Senator Barrasso was famously quoted saying, you know, if he were an emergency room doctor and only 3% of his patients made it out of the emergency room, he would lose his medical license, right? So there's these debates on both sides of the camp on ESA. Those who say the ESA is really effective will point to the 11 confirmed extinctions. Those who say the ESA is a failure will say, well, only less than 3% have recovered. And what I actually want to offer you is a totally different perspective on this issue, which is this: 1% plus 3% is only 4% of all the 2,350 species. What about the remaining 96% of species? How are they doing, right? Because those are actually the majority of listed species. And that's where we actually run into some trouble, because unfortunately, there's no very reliable information on the long-term trends for most listed species. This study, which I was part of in 2016, we looked at the Fish and Wildlife Service's reports for the long-term trends of roughly 1,300 species. And the fortunate reality is that we found roughly 50% of them were in long-term decline, even after being listed. And that only roughly 35% were stable and 8% were improving. So you might ask, why is that, right? This is one of the strongest, at least on paper, wildlife and actually environmental laws. It's one of the most innovative laws any country has adopted to save endangered species. Why are we not doing better than this? That it comes down to oftentimes money. The Fish and Wildlife Service gets roughly only 20% of all the money it needs to fully recover species. And two, there's a lot of socio-political tension with the ESA. Even if you had all the money in the world, it's not true that you can just go on anyone's backyard and say, I want to introduce species in your backyard. I want to go on this state land. I want to introduce species. There's not always the socio-political will to carry out all of the mandates of the ESA. And so that's why there's a lot of sociology and economics and psychology involved in ESA. It's a, it's a negotiation in many instances. And that's what makes ESA implementation somewhat messy, but also really interesting. And again, why we see a lot of species not necessarily doing better right after being listed. There's simply not enough money to fund the recovery actions that they need for conservation. Okay, so now we're on to the ESA structure, and this is where we'll spend roughly 20 minutes getting into some of the meat of the ESA. And what I like to do is break down this discussion into 5 separate sections. And let me just give you an overview of how all of this works, and then we'll dive into each of the components. So before anything happens under the ESA, before a species can get any money, before it gets any legal protection, it first needs to be listed as a threatened or endangered species. And when it's listed, the services are also habitat at around the same time of listing, right? So you can think of listing as sort of opening the doors to all of these supposed benefits that arise from listing. Now, those benefits fall into 2 categories in my mind. And you can think of those categories as trying to prevent bad things from happening to species and trying to for species. So if you go down sort of the left-hand side of the flow chart, let's talk about preventing some of those bad things. The ESA has some really infamous prohibitions, and we'll talk about those. And so those prohibitions are designed to manage the amount of bad activities, right, that could befall a species. But if those prohibitions were absolute, if there are no exceptions to those prohibitions, we wouldn't have a lot of the projects that we rely on in our daily lives. A lot of airports probably could not be built, or at least they couldn't be built to the size that they are built. A lot of highway, expansion projects have effects on endangered species. A lot of renewable energy projects, which are really important for fighting global climate change, kill endangered species. And if there weren't a way to authorize those types of activities, I think our entire society would be very different. So the authorization process is actually really important, and that's where a lot of Fish and Wildlife Service and NOAA Fisheries career staff spend a lot of their hours looking through permit applications, figuring out whether to issue permits. And this is where a lot of litigation around the ESA happens, because this is about how much bad activities are you going to allow to impact an endangered species and hinder its recovery progress, right? So there's a lot of emotion, there's a lot of value judgments embedded in the authorization process. So that's preventing bad things. Let's talk about doing good things. And so that's what the recovery action part of the flow chart looks like. So as I said earlier, it's not enough just to kind of prevent bad things from happening, because that's not actually going to get most species to recovery, right? It might prevent extinctions, but most species need proactive habitat management. They need lost populations to be reintroduced into the wild. They need all of these things that take money and take time. And those are the recovery actions, and they can be really difficult to implement because it oftentimes requires the voluntary collaboration of a private landowner, right, or a state agency. And not every private landowner wants to have an endangered species in their backyard, because there are legal implications to having endangered species back there. So that too is a somewhat complicated part of ESA implementation. We'll just scratch the surface of that, but this is also an ESA 102 or 103 type of course to go deeper. And then for those roughly 55 species that have gone across the finish line, they can be fully recovered and delisted. And we'll talk a little bit about that delisting process and what it means. Okay, so let's start with listing a species. What does that actually mean? The service can list a species as either endangered or threatened. And let me just sort of talk through the definitions of these, because we're going to continue to go back to them throughout our course. An endangered species is basically one that's presently in danger of extinction. And roughly 79% of all listed species fall into this endangered category. A threatened species is one that's likely to become endangered in the foreseeable future. And the likely and the foreseeable future concepts are really important. We're going to return to that in a few slides. So I just ask you to keep that in the back of your mind. And there's roughly 479 species that are threatened. Also, you might be wondering what's meant by a species under the ESA. So for you biology nerds, there's really three categories here. A species can be a full species. It can be a subspecies. So an example of a subspecies would be like the Siberian tiger, the Sumatran tiger, the Bengal tiger. Those are subspecies of tigers, right? And then a distinct population segment of a species that's a vertebrate. So it's got to have a backbone in order for it to be listed as a distinct population segment. So an example of that would be green sea turtles. There's 11 distinct populations of green sea turtles listed throughout the world. And each of those distinct population segments is basically treated as its own species under the ESA. Great. So now that you know what can be listed, let's talk about how a species gets listed. This is a simplified version of that listing process, and there's a little link at the bottom where if you really want the full-blown version, you can click on that. But in the interest of time, let's kind of quickly walk through this process. The listing process almost always begins with a petition from a nonprofit organization to list the species as either threatened or endangered. So that listing petition might be, I don't know, 50, 100, 200 pages long. And it talks about all the threats to the species, how many are out in the wild, and why it should be listed. And after the petition is submitted, the service has 90 days to decide whether there's enough information in that petition to even take a closer look. So if the petition is very poorly written, the service basically dismisses it to say, no thanks, and that's the end of the process. But most petitions will review. It's actually a fairly low bar. And you kind of have to be like half asleep writing it if you're not going to get past the 90-day stage. So once you get past the 90-day stage, then the service has 12 months from the date of listing to decide, okay, does the species actually meet the definition of threatened and endangered that we talked about in the last slide, right? And in so making that determination, the service has to return back to this question of, does the species meet the definition of threatened or endangered? And so how does that actually occur? Let's look at this slide. The ESA says the service has to consider 5 threat factors in deciding whether the species meets the definition of threatened and endangered. And those threat factors are habitat loss, which is the main threat to most species, overuse. This really refers to like commercial exploitation. If there's like too much poaching or trade of the species, that's overuse. Disease and predation, that's pretty self-evident. Inadequate regulations. This oftentimes refers to inadequate state regulations, inadequate international agreements where the ESA needs to step in because what currently exists isn't enough to protect a species legally, right? And then there's a catch-all, which is everything else. Right, so the service has to walk through all of these 5 factors in deciding whether the species is threatened or endangered. And the ESA also has a really interesting passage here. It says the decision on whether to list a species must be based solely on the best scientific and commercial data available. I'm here to tell you that's an illusion. It is not true. You'll oftentimes hear that it's true, but it's simply not. Sometimes you'll hear that, well, ESA decisions have to be based solely on science. That's never been true from the beginning. And let me just sort of illustrate why. In reality, science alone can never make this determination. There's always a non-science policy judgment involved. So for example, remember that definition of threatened we just talked about earlier? Likely to become endangered in the foreseeable future. So how likely is likely? Is it 20%? Is it 40%, 60%, 80%? There's no scientifically objective answer to that question. And in surveys that they've done of service biologists, you'll get wildly different answers depending on who you ask. The service has never prescribed a specific number for how likely is likely, nor does the ESA prescribe that. And so the real world practice is there's a lot of interpretation here as to how likely is likely. Same thing with foreseeable future. How far into the future is foreseeable? Of course, science can partly answer that question, but it's also a judgment about how comfortable am I as a Fish and Wildlife Service biologist looking out into the future, right? Some people aren't comfortable looking past 15 years. They just say, no, that's too much uncertainty for me. And others will be gung-ho and say, I'll easily project 60 years into the future. I feel really confident about 60 years, right? There's no objectively right answer to either of those questions. So what science can tell us is what the risk of extinction is, but it cannot tell us what that risk should be, right, in order for a species to deserve protection. And because the service has never made clear what this should be question is, there can be a lot of reasonable disagreements about whether a species warrants listing. And this is the main reason a lot of ESA listing decisions are so controversial. There simply doesn't exist after 45 years a really bright line objective test for what's not listed, what's threatened, and what's endangered. There have been various qualitative attempts to separate those categories, but there's not again, an objective standard that's out there. If you want to learn more about what I think is just really fascinating topic, I think the best article out there is written by Holly Doremus. You'll see this at the bottom of the slide. She's a professor at UC Berkeley Law School. And she, in this groundbreaking sort of article, talks about why it's really not just a science question, it's a policy question. All right. So let's get back to our listing process. We talked about how that 12-month finding is made. So then what happens next, right? There's really 3 outcomes at this stage. And I'll just go from left to right. The first outcome is listing is not warranted. The species doesn't meet the definition of threatened or endangered, and then that's the end of the process. The second outcome is, yes, the species does meet the definition of threatened or endangered, but there isn't enough money to continue with the listing process. So we get back to money again, right? If there isn't enough money to continue with the additional steps we see here, the species basically becomes what's called a candidate for listing. In other words, it actually biologically meets the definition of a threatened and endangered species, but it can't get any protections because there's not enough money to move the listing process forward. As of a few years ago, there were hundreds of species that have been waiting for many, many years as a candidate. And the Obama administration did actually a really good job clearing that backlog of hundreds of candidate species, such that today there's only about 22 candidate species. So that's really good. But that number is going to grow if Congress doesn't continue to fund the listing program. Because what's going to happen, there's going to be more and more petitions to list species, but if there's not the money to proceed with the following steps, then species have to be put in the candidate list, right? There's simply not enough money to do a proposed rule and a final rule. And then in good times like we are today, believe it or not, what the service is trying to do is to say, listing is warranted, if it is warranted, and there's enough money to do a proposed listing rule. And so what is a proposed listing rule? It's a proposed regulation that the service puts out for public comment, and it asks the public, do you have any more information on this species? Is there a reason you can offer us to consider why we shouldn't list the species or why we should list the species? And as part of that proposed process, the service also puts out the rule for scientific peer review, right? So this is where the peer review process happens. And after considering all those comments, the public comments, the scientific peer review, the service has one final off-ramp. It can actually withdraw the proposed rule and say, you know what, there's all this information that came in, we're gonna pull the plug at the 11th hour and no listing. And that's actually happened with a few species in recent years. But more often than not, the service proceeds with a final rule to list the species. And that final rule needs to generally be implemented or finalized a year after the proposed rule. And after that final rule is in the Federal Register, usually in about 60 days, it becomes effective and the species is officially listed, which means it starts getting legal protections under the ESA. So this slide just shows you sort of the taxonomic breakdown of the species in the US. And the one thing I wanted to point out to you is this, 57% of all currently listed species are plants, 17% are invertebrates. So 2/3 of all US listed species are plants and invertebrates. These are not the poster child of what you see on the front cover of National Geographic or newspapers, right, on endangered species. But this is the reality of what's on the list. This is the reality of what biodiversity is made up right around the world. So I just want to put that out there because grizzly bears, polar bears, and bald eagles are more of the exception rather than the rule. I also wanted to show you this map, which is a breakdown of where species occur throughout the country. And so what I find interesting is actually Hawaii, which is at the bottom of this slide here. It is in dark green. Hawaii has 30% of all the listed species in the US. And those species, most of them are found nowhere else but in Hawaii. So the endangered species sort of crisis, so to speak, is to a large degree centered on Hawaii if you look at simply the number of species. But on a per species basis, Hawaii gets very, very little money. And there are various political reasons for that that we can discuss at another time. But again, this is the geographic breakdown of listed species in the country. Great. So earlier I talked about critical habitat. Now let's dig in a little bit deeper about what critical habitat means. So around the same time as listing, the service is supposed to designate critical habitat. And there's two types of critical habitat that can be designated. Both of these are super controversial. These are actually some of the most controversial aspects of the ESA today. A lot of people hate having their backyards designated as critical habitat. And in fact, last year, there was a case that made it all the way up to the Supreme Court involving. So this is really contentious at the end of the day. So two types of critical habitat. First is habitat that's currently occupied by a species. So a species is actually found there. The second type is a habitat that's not currently occupied by the species. And really, without getting too much into the weeds, I think the main takeaway for you to remember is that the habitat must have essential features needed to recover the species. So what does that mean? Places for the species to hide, food for the species, the right environmental conditions, right? It's sort of like your home, right? What are the aspects of your home that make it habitable? Those are almost the same components that you think of for critical habitat. And another thought I wanted to leave you with is that critical habitat, what always qualifies for the definition of critical habitat is what is actually critical habitat at the end of the day. Because there are, and the first one is actually really important because this is one of the very few areas of the ESA where economic impacts can specifically be considered in a decision. And so in particular, the service can exclude areas from critical habitat, even if they meet the definition of critical habitat, based on the economic and other impacts of designating that critical habitat. So for example, if the economic impacts to a private landowner, right, exceeds the conservation benefits from designating that critical habitat, the Fish and Wildlife Service can say, we're going to exclude that property from critical habitat, even though it meets the definition of critical habitat. The services also have the option not to designate critical habitat if doing so will threaten the species. So for example, if you draw a map of critical habitat and you put it out there, and then pretty endangered box turtle that I can poach and sell on the internet, then the service can say, okay, we're not going to designate critical habitat. That's a fairly rare exception. And then the final one I want to mention is that the service can delay designating critical habitat if there isn't enough information to determine what is critical habitat. And so this can be a very real situation because you can imagine at the time of listing how little information is really available on the biology of species, right? A lot of these species, there's really just not that much information on. And so the service can find it really hard to designate critical habitat. But in the past, when the services have made this not determinable finding, they've oftentimes lost in court. So it's actually pretty tough for the service legally to make a not determinable finding. And this raises a lot of controversy about how good critical habitat is if the service doesn't have all the information it needs to for recovery at the time of listing. This is a really quick map showing you all designated Texas and other parts of the southern US are an example of that. All right. Okay, so that's listing in critical habitat. Let's talk about the prohibitions under the ESA now, because this is kind of what a lot of people who want to get species listed are after, right? These are the what stops bad activities from happening. So there are two prohibitions that we need to know about. The first one appears in section 9 of the ESA. And so the ESA is oftentimes called the pit bull of environmental laws. And if that is true, then section 9 is, I think, where you'll find its canine teeth. All right, because the section 9 has the really broad prohibitions. The first two relate to foreign and interstate trade of listed species. And that's all good, but the most important section 9 prohibition, and is the really infamous one, is the prohibition on take of an endangered animal species. And take is defined really broadly. It means harass, harm, hunt, shoot, wound, kill, so forth, or an attempt to do any of those things, right? And so this take prohibition is really far-reaching. And in particular, I want to focus your attention on the harm prohibition. That's the second prohibition in this definition of take, because it's one of the most significant. It covers modifying habitat if doing so is likely to kill or injure a species. And so this was actually a real innovation in the ESA when harm was interpreted to include habitat modification that kills or injures a wild. Because at the time, there was no other country, and even today, I'm not aware of any other country that has actually adopted this definition of harm, where it actually can apply to not just shooting an endangered species or grabbing it and you know, putting it in your suitcase, but modifying its habitat in a way that injures the species. there's a concern that, for example, you're going to bulldoze, this habitat. Well, in the process of bulldozing this habitat, you might kill some endangered species, right? That's what brings that activity under the ESA's umbrella. I want to note one thing. The take prohibition doesn't actually apply to plants. So remember earlier we said 57% of listed species are plants. Well, the take prohibition doesn't apply. Plants are covered by a less stringent standard under Section 9. And the last thing I'll note here is that the Section 9 prohibitions apply by default only to endangered species. Threatened species are supposed to receive Section 9 prohibitions on a case-by-case basis. And it's through something called a 4D rule, which some of you might have heard of because this is one of the topics of the Trump administration regulatory reforms. So what happened is that in the 1970s, the Fish and Wildlife Service by policy had decided to automatically extend all of the Section 9 prohibitions for endangered species to all threatened species. So whenever a threatened species would be listed, it automatically is treated as an endangered species. And this has been the practice since the 1970s. But the Trump administration has proposed to basically do a 180 on that policy. And what it's proposed to say is that threatened species that are listed in the future do not automatically get any Section 9 prohibitions. Any of those protections need to be extended on a case-by-case basis. So this has been really controversial, especially within the environmental community. Many people view this as a pretty significant sort of degradation of the protections for threatened species. All right. So now that you know about the Section 9 take prohibitions, let's compare it to the ESA's other primary prohibition, which is the one that no federal agency can jeopardize a species' existence or adversely modify its critical habitat, right? So two things we have to be aware of: Section 9 take prohibition, and then Section 7, the jeopardy prohibition and the prohibition on adverse modification. Let's quickly compare the two. The take prohibition applies to anyone under US jurisdiction. The jeopardy adverse modification only applies to federal agency activities. The take prohibition is actually fairly broad, as we saw earlier. It includes all those activities like harm, harass, shooting, capturing. The jeopardy adverse modification is mostly limited to this definition that you can't threaten a species survival. So it's a very different standard from the take prohibition. The take prohibition, as we saw earlier, doesn't protect habitat alone, right? It only protects habitat to the extent that destroying that habitat also kills and injures an animal. Versus critical habitat, even unoccupied critical habitat can be protected because you can't adversely modify that habitat. So you don't actually need a critter present in the area in order for the adverse modification prohibition to be triggered. The take prohibition only applies to individual critters. It doesn't apply at the scale of the entire species. Versus the jeopardy adverse modification prohibition only applies at the scale of the entire species. You can't jeopardize just a single polar bear or a single, least-Bell's vireo. And then finally, we saw earlier, the take prohibition applies only to animals versus jeopardy adverse modification applies to all listed species, including plants. All right, so let's quickly go through the Section 9 process. Now that you know about the main prohibitions, the ESA sets up two different authorization processes depending on whether a federal agency is involved, right? So let's say there's no federal involvement. Let's say, hypothetically, you own 200 acres of forest, right? And you want to help an endangered bird that lives in that forest by cutting back some invasive plants that are destroying or degrading the species habitat. But in removing those plants, you might harm a few birds in the process, and therefore that would be take, right? That would be prohibited under Section 9. So what you would need to do is to get a permit from the Fish and Wildlife Service that allows you to harm that bird in the process of trying to do good things for the bird. And that permit is called an enhancement of survival permit. And all of those conservation activities you would do would need to be described in a conservation agreement that you submit to the service for its approval. So that's if you want to do good things for a species. Now let's change the hypothetical. You still have your 200 acres of forest, but instead of restoring the habitat, let's say you want to cut down 100 of those acres because you want to build a private golf course for you and your friends, right? So building a golf course isn't really going to help the species recovery. In fact, it's probably going to really hurt the species recovery, right? But there are plenty of golf courses in the country. So how do we have all these golf courses and not have all these violations of the ESA? The way that happens is you can get a permit to cut down those 100 acres of trees in theory and build your golf course. And that permit is called an incidental take permit. But to get that permit, you first need to write what's called a habitat conservation plan, or an HCP. And you have to give it to the service for its review. So in that plan, you basically have to describe how you're going to try to minimize the footprint of your golf course, and how you're going to try to offset those 100 acres of lost habitat. Maybe you have to plant some trees in your neighbor's backyard, or you have to, pay a nonprofit organization to do some captive propagation for that bird. So you have to do some type of offset. And there are over 1,200 habitat conservation plans that have been approved under the ESA, covering over 46 million acres of land in the US. So this is not a small deal. And in fact, this is a map of all of the areas in California that are covered by an HCP. You can see large parts of California are covered by an HCP, such as this one written by the city of San Diego 2 years ago, as part of the city's expansion and development. Basically, that expansion would involve destroying these temporary wetlands called vernal pools that are home to certain endangered species. And the only way you can destroy those ponds is to try to offset the impacts elsewhere. All right, so far we've talked about private activities. Now let's talk about activities that federal agencies authorize, fund, or carry out. So these are basically activities that have some federal connection, right? Because the process for getting authorizations for those activities are different from the ones we just discussed in our two hypotheticals. Many activities fall into this category. Like I said, airports, military training, a lot of renewable energy projects, they all go through this federal process. And that process occurs under Section 7 of the ESA, which basically requires that a federal agency that wants to do one of these projects, they have to consult with the service to ensure that that project isn't going to violate those two prohibitions I talked about earlier, jeopardy and adverse modification of critical habitat. So let's quickly see how this consultation process works, because this is actually a lot of the services work under the ESA. If a federal agency wants to carry out a project where a listed species may be present, it first needs to determine if the project may affect the species. If it may affect a species, and this means any effect, good or bad. So you want to do some good things for a species. Those are entirely beneficial effects. That's still a may effect. You still have to go through the consultation process. If the answer to this question is yes, then the question is it likely to adversely affect the species, right? So this is where you have the fork in the road between harmful projects and beneficial projects. So if it's a purely beneficial project, then consultation ends, you get what's called a biological assessment, and you're good to go. But if you have any adverse effects, and usually this means that there's any take, right? If you're going to take an individual of a species, what happens is you're going to you basically get a likely to adversely affect determination, and you have to go to a formal consultation. So there's these two parts of the process. Everything I've talked about so far is called informal consultation. And if you're likely to take a species, then you have to go to formal consultation. And formal consultation involves a much more detailed analysis. And that makes sense, right? Because now you have some real prospect of harming the species. And so the Fish and Wildlife Service, or NIMS, wants to take a closer look to make sure you're not going to cause too much harm to the species. And so in that formal consultation process, the question that's being answered is, are we in a jeopardy situation, or are we in an adverse modification situation? And there's three possible outcomes here. The first one is no, in which case you get a permit that allows you to take the species and you can go ahead with your project, like building your airport and so forth. The second one is yes, it's actually going to jeopardize or adversely modify critical habitat, but there's something called reasonable and prudent alternatives, which are basically conservation actions you can take to offset or reduce the effects of the project, and therefore avoid jeopardy, right? So this is, if you don't do the RPAs, you're going to get jeopardy. But if you do carry out these conservation measures, you can avoid jeopardy. And then the third possible situation is sort of the worst one, right? You have a jeopardy situation and there's no alternative to your project. And in that case, your project cannot proceed without violating the ESA, unless you get the special exemption from a committee called the God Squad, so-called because it's effectively playing God. It can almost allow a species to go extinct if necessary. In the history of the ESA, the God Squad has only been convened 3 times. So it's not a frequent occurrence. All right. So Section 7 oftentimes has a bad reputation for stopping projects and causing economic upheaval. And so the question oftentimes is this actually correct? Is this reputation still deserved? And so 4 years ago, my colleague and I looked at the results of every Fish and Wildlife Service consultation from 2008 through 2015. There were 88,290 consultations. So what you see in the parentheses are the numbers of consultations at each of these stages. 88,290 consultations by Fish and Wildlife Service during this 7.5-year period. Amazingly, 7% of those consultations, only 7%, got a likely to adversely affect determination, meaning only 7% of those projects were likely to have any type of take. And then of those 7%, only 2 projects resulted in jeopardy, and both of those projects had alternatives to allow the project to proceed. So this was, we actually had this published in the Proceedings of the National Academy of Sciences because it really busted this myth that a lot of people have about Section 7, which is it's the super, regulatory hammer that stops all of these projects. And what we found after looking at all of these, every consultation is there's almost no findings of jeopardy anymore. This wasn't the case in the 80s. In the 80s, something like 80% of all consultations, 20% ended in jeopardy. But not anymore. And I think there's a political reason behind this that we can get into at another time, but the numbers are what they are. Okay, we're going to try to wrap up fairly soon here. So let's quickly talk about recovery and delisting of a species. The ESA requires the service to develop and implement a recovery plan for every species unless that plan will not help the species recovery. And so as a general matter, the services have decided that if a species occurs entirely overseas, they're not going to do a recovery plan for that species because their view is that there's not too much the ESA can do to help foreign species. And that's generally true. There are a few exceptions to that. But roughly 650 of the species that are listed are foreign species and therefore will never have recovery plans. You can think of the recovery plan as basically a roadmap for how to recover the species. And so what does that really mean? The ESA has 3 mandatory components of every recovery plan. The first one is there has to be site-specific management actions. And the one I've provided here as an example. This one is out of a recovery plan for this Laguna Mountain skipper, and it basically says you have to protect the habitat wherever the skipper is found in the long term. The second component is objective measurable criteria for recovering the species. In other words, how do you know when a species can be delisted as recovered or can be downlisted if it's threatened? So here's an example for a fish called a mad tom. And it basically says there needs to be a viable population in this creek and at least one other stream. So that's fairly objective and you can measure it. And then finally, there needs to be the time and cost of recovery. So here's an example. Recovery is anticipated to take 10 years and cost a measly $12 million. So this was from, I think, Preble's jumping mouse recovery plan. So these are the only 3 components that are required in every recovery plan. Okay, now we're going to get to the realities of how recovery plans are implemented. This is a study I did with my colleague last year where we looked at every species, every recovery plan that's ever been published. And the question is, how many species even have recovery plans? We know they're a good thing, but we know, there's a lot of slippage in the ESA. So what we find is that 25% of species that actually deserve recovery plans still don't have them as of last year. And it's getting worse. So if you look at the number of species that are listed, that's growing, but the number of species without recovery plans is also growing, and it's far outpacing the number of species with recovery plans, right? So why is that? Because it's much faster to list a species than it is to write a 100 or 200-page recovery plan. So the pace of listing is so far exceeding the pace of recovery plan writing that we basically have this growing backlog of species without recovery plans. Here's another depressing aspect of recovery plan implementation. So we also looked at the age of every recovery plan. The median age is 20.5 years. It's old enough to vote if it were a person. 10% of recovery plans are less than 10 years old. That's really good. 10% of them are older than 31.7 years. Those recovery plans are so outdated as to be almost completely worthless. But that is the roadmap for how to recover species. And I think that's one reason 50% of species are still in long-term decline. There just isn't enough money to do everything that needs to be done for those species. All right. Now, the other thing relating to recovery that the ESA mandates is something called a 5-year review. So every 5 years, I should say, the ESA requires a service to review the status of all listed species and describe whether the species is doing better, worse, or they simply don't know what's happening. And that 5-year review also needs to indicate whether the species is ready to be delisted because it's recovered. Because of chronic funding shortfalls, as of January 2017, when we last pulled this data, over 1,000 species had 5-year reviews that were out of date. So that far exceeds the number of 5-year reviews that are actually timely. And so again, this is another area where the dreams of this ideal ESA start to fall apart when you look at just how little funding and resources are available to conserve these species. All right, almost at the finish line here. So delisting. If a species is recovered, then the service may delist it. And this process is very similar to the listing process. You have a proposed rule to delist the species. You take public comment, you do a peer review, and then if all goes as planned, then you can delist the species. The one thing I want to flag for you is this. In general, the service uses the delisting criteria we talked about earlier, those objective measurable criteria, to determine whether a species is recovered. But the services may choose to ignore those criteria as well, because we have this case from the DC Circuit in 2012 on the flying squirrel in West Virginia that basically held recovery plans are considered not legally binding on the agencies, so they're guidance documents. And so this upset a lot of conservationists because you spend all of these years drafting recovery plans, you have all these conservation partners following recovery plans, but the service in the end can say, not quite just kidding, but we don't actually have to follow every one of those criteria, right? We can ignore a few. The service has not gone out of its way to ignore too many recovery plans, but in theory, it can do that. And I suspect we will continue to see instances where the service will ignore certain recovery criteria. And then after delisting, the service must work with states to monitor the status of species every 5 years. So the bald eagle was delisted roughly a decade ago. This is the plan to continue monitoring the bald eagle for at least 5 years after delisting, just to make sure it doesn't tank after all the ESA prohibitions are released, right? That's something of big concern to a lot of conservation groups. All right, special topics real quickly. You might have heard a lot about litigation under the ESA and so forth. So we need to cover judicial review quickly. The ESA has a provision that allows a person to enforce any violation of the ESA, including against the services for violating those deadlines on listing and critical habitat that we talked about earlier. That 90-day deadline, the 12-month deadline, those can be enforced against the service. Also, a separate law called the Administrative Procedure Act allows citizens to sue the services for implementing the ESA in an arbitrary and capricious manner. So let's say the service says, you know what, there's this really horrible project, but we don't want to call jeopardy, right? Because maybe it's very politically difficult to make that jeopardy call or whatever other reason. An NGO, like my former employer, Defenders of Wildlife, can sue the service to say, you know what, we think that's jeopardy. Your call of non-jeopardy is arbitrary and capricious, and it violates the ESA. Okay, the second topic I want to cover is candidate species. If you remember earlier, these are species that are sort of stuck in this eternal sort of loop of not becoming listed. But that also, there's a silver lining to all of that, because it actually provides an opportunity for states and others to do conservation practices to try to preclude listing. And so some of you might be familiar. It was a candidate for over 10 years. And because of this enormous effort on the part of the Fish and Wildlife Service and Bureau of Land Management and others, the Fish and Wildlife Service felt comfortable not listing that species through all of these candidate conservation measures and agreements. And then finally, this is a link to the Fish and Wildlife Service's summary of the extensive Trump administration reforms to the ESA. So if you want to learn more, there is the Fish and Wildlife Service's interpretation. And then finally, Senator Barrasso from Wyoming has issued a draft bill proposing very comprehensive reforms to the ESA. So that's also been the topic of a number of media stories. This is a list if you want to learn more about the ESA. I've put together some of the resources I use quite a bit. And then finally, to end on a happy note, or a pretty cool note, there's a Hawaiian plant called Hibiscadelphus woodi that was declared extinct by the conservation community in 2016. Earlier this year, it was rediscovered using drones because it lives, as you can see, on this really steep cliff in Hawaii that's very difficult for humans to access. And so they found these plants living on the edge of the cliff. And for those who want to be optimists, this is a story of how actually technology, things you can buy on Amazon.com, these drones, can allow us to rediscover certain endangered species that might have been overlooked in past surveys. So that's it. If you have questions, my email down there is jake@policyinnovation.org. Thanks for your interest, and happy to take questions.
Wonderful. I guess we'll start with questions in the room. Do we have any questions to ask the panel?
Thank you. Thank you for those really excellent talks. I'd like to ask Ms. Navarro, if you could say maybe a little bit about the state NEPAs, the little NEPAs, your practice under those, how they vary.
Sure, and I have to admit I don't know a lot about the state NEPAs because I've always been a lawyer practicing in the federal arena. I would say that probably the most infamous one is the one in California, the California Environmental Quality Act, which has a number of provisions that are very similar to or even stronger than NEPA. And so a lot of projects that are done in California by the federal government and others tend to get kind of wrapped up in the CEQA process and also in CEQA litigation in California. But I honestly don't know a lot about other state NEPAs except to know that there are some and they vary in terms of their requirements.
Okay. Hi, I have an ESA question. You were talking about, you had your slide on the analysis of Chapter 7 consultation and what percentage it actually stops. The more common complaint that I hear is that ESA consultation just slows down the entire process. And I'm wondering if you've done any analysis of that.
Yeah, we have. So the study, and I can give you the link to it afterwards, we also looked at the official duration of both informal and formal consultations. So if I recall, the median duration of informal consultations was 67, informal consultations was 14 days, and formal consultations was 67 days. But that's not the full picture because the official clock is only when the service gets all the information it needs to get. There can be a lot of background preparation of, studies and so forth that leads to when you start the clock for informal and formal consultations. So it is true that consultations can slow down projects, but it's also true that, for a lot of these species, we simply don't know enough information, right? About their biology, about where they're found. So sometimes additional surveys or additional back and forth discussions are really useful to actually avoiding jeopardy. Because what happens is if you don't have enough information, you don't give it to the service is actually supposed to give the species the benefit of the doubt if there's uncertainty. So what does benefit of the doubt means? It means assuming the impacts are probably going to be worse than they actually are on the ground. So sometimes it's really beneficial for the project proponent to spend a little bit more time, get that information if it wants to avoid a jeopardy finding.
Thank you.
Hi, this is another ESA question. I believe I understand that the ESA requires no net loss to critical habitat. Is there any language or thought I'd read that there was a requirement for net benefit to critical habitat. Is that still required, or is that where does that stand?
Yeah, so it's the whole debate about sort of ensuring against no net loss versus net benefit. Actually, it's broader than just critical habitat. So what happened was during the Obama administration, right? They had put out a policy on mitigation, the Fish and Wildlife Service, and what it said was that the Fish and Wildlife Service would strive, just as a goal, not a legal requirement, would strive to negotiate towards a net benefit. Because that's the only way you're going to really recover species, right? If all you're negotiating is just a status quo, you're not going to move the needle forward. And the Trump administration basically rescinded that policy. So that might have been what you were referring to. I don't know if there's any.
Well, you know, I think there was it was definitely a policy question, and I think there was a lot of gray in terms of whether there was any legal basis for pursuing a net benefit approach, because even when it is postured as being a voluntary approach, I think the perception was that a lot of folks felt like it was being imposed. And the question of whether there is any statutory or other basis for net benefit, I think, was a very live one, which is why the Trump administration took another look at it.
Wonderful. Do we have any questions in the room before we turn it to the go-to questions? Yep. All right. We do have a question for Jake. If the 4D rules revised with currently threatened species lose their default take prohibitions?
No, so the rescission, or the proposed rescission of that 4D rule from the 1970s doesn't affect currently listed species. It only affects threatened species moving forward. But, and this is an important but, nothing prevents the Fish and Wildlife Service from going back to a species that's already threatened to say, we don't want the general rule to apply. We only want this, a specific rule that has less protections to apply. And this isn't unique to this administration. The Obama administration, other administrations did that. They went back to species that were listed years ago and said, now's the time to do a more tailored 4D rule that has less protections. And sometimes those less protections actually make sense. You don't need to prohibit every activity that has some harm to endangered species. Some activities have only minimal harm, right? But to answer your question, yeah, it only applies moving forward.
Wonderful. And we also have a question for Anne. What do you think the biggest changes might be to the new proposed NEPA rule? How will this negatively or positively impact those who have to follow NEPA, and who will be impacted in terms of environmental protections?
That's a great question. I think, as I briefly mentioned during my presentation, I think that CEQ will try to further refine the definition of indirect impacts because it tends to cause the most confusion in terms of writing NEPA documents and then in terms of litigating the sufficiency of NEPA documents. How they're going to do that remains to be seen, but you know, taking indirect impacts just as kind of a conceptual out there concept, there's no clear sideboards as to where indirect effects stop. You know, where is the chain of causation so attenuated from the federal action that it's not legally required and doesn't make sense for the federal agency to kind of take ownership of an impact in order to have to analyze it. So I think CEQ is definitely investing some brain power in thinking about that option. There is Supreme Court case law on it that suggests tying indirect impacts to a tort law kind of causation analysis. So I think it'll be interesting to see how CEQ does grapple with that problem. In terms of kind of what the outcome is going to be, I mean, I think everybody is you know, intent for NEPA to remain an important tool for federal decision makers, but to try to smooth out some of the rough edges that have resulted in so much litigation. I'm sure in the near term, any final rule will result in even more litigation as people kind of fight over the parameters and that settles out.
Wonderful, thank you. We do also have a question for Jake. How do you think implementation of ESA can address potential for climate change to affect/change the location of critical habitats?
How can it affect, just so I follow the question, how can ESA implementation affect critical habitat in terms of where it's designated? Is that the question?
That seems to be where yes.
Okay, all right, so I think here's the best example. Remember earlier I talked about occupied and unoccupied critical habitat, right? And so if the service can project climate change impacts, let's say 40 years into the future, and it recognizes that an area that's not currently occupied may need to be occupied 30 years from now because that area is needed as a climate change refugia for a species, then the service can in theory designate that area as unoccupied critical habitat today to try to protect it. But there's a lot more to the story to that. I'll just offer sort of one thought, which is historically, a very, very, very small percentage of the critical habitat that's been designated is unoccupied. I believe for Fish and Wildlife Service, less than 3% of all the critical habitat I showed on that map is unoccupied. For National Marine Fisheries Service, I think it's 0.9%. So unoccupied habitat has not been well used in the past. It is in theory a tool to help address climate change, but as we saw here, critical habitat is protected only through the Section 7 process, and Section 7 is only triggered when you have a federal action. So if you have a purely private action, it may not do very much for you.
Wonderful, thank you. We do just have another question for Jake regarding ESA. When a state has additional protected habitat or species, how does a project that triggers both federal and state ESA issues combine the federal and state review and permitting process?
Yeah, great question. So there aren't that many states that have a state ESA, right? There's actually a report that came out 2 years ago from UC Irvine Law School that looked at all the state ESA laws, and they found that most of them don't actually prohibit take, and most of them don't actually have a permitting process. For those few states that do, Florida is an example, California is an example, Hawaii is an example. There are attempts to try to combine those two processes into a single one. In Florida, actually, they were proposing to do this to basically say the federal permit is sufficient to comply with state laws as well. Some attempts to do that, they haven't gone very far.
Perfect. And do we have any questions in the room? All right.
Thank you. One more question about the ESA. I had read that one of the proposals was to change the way that citizen suits would be available. And one of the criticisms, I think it might have been Senator Barrasso made or someone else, is that too much of the ESA budget is going to litigation and not enough is actually going to improve species habitat and the other things that the ESA identifies as critical. So since you kind of done a lot of work with data, I just wonder whether you had any data on where the budget of the Fish and Wildlife Service and NOAA are going, and if you had any comments about that proposition. Is it correct? Is it incorrect? You don't know.
Yeah. So just to clarify, this actually refers to a legislative proposal. It wouldn't be the Trump administration's regulatory proposals. So it's just for folks in the room. We're talking about the Barrasso proposed amendment to the ESA itself. I am not aware of data from the Justice Department of Interior about how much is spent on litigation. I don't know if on ESA.
Well, so I spent 2 years at Interior before I came into the private sector, and I would say just my gut sense is that litigation certainly does have an impact on the ability of fish to implement the ESA program, but it's not necessarily a direct budgetary impact. It's more of an impact on the same people who are handling listing, delisting, things like that, also have to provide litigation support in terms of providing their expertise when it comes to dealing with these cases. So there's kind of a time issue, and then also litigation can very much take control away from the Fish and Wildlife Service in terms of how it prioritizes its actions. So there's a definite impact. I'm not, I mean, I don't know the budget numbers. I'm not sure it's really a direct funding issue so much as a prioritization of resources issue.
Right. And just to quickly answer your final question about how I personally feel, my sense is a lot of litigation is important because there are other incentives sometimes for federal agencies to make decisions that are difficult, and the citizen supervision is really important, right, for accountability. On the other hand, some litigation in my mind is like, shooting fish in a barrel. It's not necessarily on the whole helping species, and they're just really easy lawsuits where, for example, enforcing the listing deadline, right? That's one where we know the service cannot meet all of those deadlines because there's just not enough funding for it, right? So that's the type of lawsuit where it can really shift resources and priorities and can be a problem for the agencies.
Well, and we saw that happen in, I don't know, less than 10 years ago in the so-called listing wars.
Right.
If you kind of Google around for that, you'll find some very interesting articles about how the service was sued and how that ended up really reordering its priorities because those statutory deadlines are very clear, but the service can't meet them all.
Thank you. Do we have any other questions in the room?
Hi, thank you both so much. I have a question for Anne. Earlier, Jake referred to the ESA as the pit bull of environmental law. I've also heard NEPA referred to as the Magna Carta of environmental law. I was wondering if you had heard this, how you interpret it, and what insights this reference can provide for us.
Well, that's an interesting question. I mean, if you ask different lawyers who practice in different areas of environmental law, I'm sure they all think their little statute is the most important one and has the best pet name. One of my partners is all into the Clean Air Act, and, he thinks the rest of this is completely unimportant. So, yeah, I've certainly heard NEPA referred to as the Magna Carta environmental law. I mean, I guess I would view that as suggesting that NEPA is very foundational to environmental protection because while it doesn't directly regulate or protect, as we've discussed, it makes the federal government think about things and hopefully make better decisions. So from that perspective, I think it's the foundation that kind of underpins all the more specific environmental laws that get at particular issues.
Thank you. Do we have any more questions in the room before we propose one more question from online? All right, I actually had a question myself. Jake, you briefly mentioned the role of technology in identifying threatened or endangered or even almost extinct species. In your experience, what is the role that technology is playing, whether it's drones, submersibles, or sensory tools and technology in finding these, I guess, rare or harder to locate species?
Not a whole lot just yet, and that's why I pulled up that example because it's such an unusual and really cool example. The one area I'll just provide by example that I did a bunch of work on in my prior job was actually using satellite imagery to figure out where there's violations of the ESA because the service actually doesn't have enough resources for on-the-ground enforcement. So we just use Google Maps. You can get some pretty good images of people's backyards in Google Maps, and you can compare it to the terms of a permit, like the incidental take permit or the Section 7 consultation. And you can see whether people are actually complying with the footprint of the project. And we found a number of violations of the ESA. So that right now is where literally any of you can go on Google, get a permit, and start crowdsourcing, right? ESA compliance. So there's some really low-hanging fruits for technology, and then some future areas like use of drones to better identify rare species.
Wonderful. And we actually received one quick question regarding, I guess, finding information. You mentioned multiple articles that were great to look at. Do you have any suggestions for books regarding ESA?
I do, in fact. One of them is the last one. Endangered Species Act Law, Policy, and Perspectives. This is the most useful book that I've seen on not just how the ESA is written, but how it's actually implemented.
Perfect, thank you. And do we have any other last minute questions before we conclude today's program in the room? No? All right. Well, let me quickly run up here. I'd like to extend a huge thank you to the participants for joining us today and for your thoughtful questions, as well as our participants online. We hope that you continue to think about the many opportunities and facets of NEPA, ESA, and the fundamentals of environmental law. We're so grateful for your participation in ELI's annual summer school series, and we hope to welcome you back to the Basics of Clean Water Act next Tuesday here at ELI. I want to also extend a huge thank you to our fantastic panel, Jake and Ann. You've contributed so much, and thank you so much for lending your time and expertise and leadership to the summer school series. Thank you all.
Great.